Good afternoon, and thank you for joining us today. I would like to welcome you to FortneyScott's Employer Briefing. These monthly briefings address COVID pandemic-related updates and other developments affecting our society, including the Black Lives Matter movement, as well as key judicial, legislative, and policy changes. This briefing will be recorded. Everyone who registered today will be registered for all future employer briefings. I want to address some preliminary items before we begin. Currently, all listeners' phones are muted. At any time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's briefing will address how the historical 2020 election results will affect the federal response to the COVID-19 pandemic, congressional actions in the employment sphere, the corporate response to issues of inequality and diversity, and enforcement policies and actions by the agencies. The presenters are FortneyScott attorneys David Fortney, Nita Beecher, and Bert Fishman. I will now turn the program over to David Fortney to start our briefing.
Great, and thank you, Valerie, and good morning, everyone, and good afternoon, depending on which time zone you're in. It's great to have everyone back, and it's great to be here with both Nita Beecher and Bert Fishman. Nita has an audio connection, but does not seem to have a video connection this morning, so she is with us. Nita, do you want to say hello?
Hi, everyone. Sorry about that. I'm having the pandemic problem.
No problem. And Bert, of course, is with us too.
Good morning, everybody. Thanks for joining us.
We're here, and Nita will be the voice, but not a video box. Well, let's take care of a couple of housekeepings because obviously there's a lot of developments to cover. As many of you know, at FortneyScott, we are a Washington, D.C. based law firm. We do represent and counsel employers, including federal contractors, on a wide range of federal workplace law developments. We deal with the agencies a tremendous amount, as well as with the Hill, and we have very deep expertise as represented by the attorneys on this call. Next slide, please. With respect to today, we are, of course, going to provide information on a number of legal developments and legal related developments. The purpose of the call, though, is, of course, informational, and we would encourage each and every one of our attendees to consult with their experienced employment counsel to understand specifically how these developments may impact their particular circumstances. All right, well, let's take a moment then and just talk about some of the recent developments and matters. And obviously we have a tremendous amount going on. We've got a very challenging transition. We have congressional action and we have the agencies. So this is perhaps, and of course we continue to have COVID. So this is what we would like to cover in the next 58 minutes or so we have with you today. We want to give you the update on the COVID-19 surge. We want to, I'm sorry, last slide, please. Want to just briefly touch, thank you, on the lame duck and transition. Want to delve in a little bit on the what we expect from the Biden administration and the 117th Congress that will convene in January. All of that is beginning to shape up with more detail. And of course, we want to talk about what the federal agencies are up to. They are not asleep. They are, in fact, are in many cases becoming more active in these final 50 days or so. And then finally, we want to talk about diversity, equity, and inclusion and the latest update on that. So with that, let's jump right into the most recent news on COVID. I'm going to ask Nita to lead that discussion. And obviously, the news is bleak. But Nita, where are we?
Well, I think the news is bleak. I think when you think about the deaths were up 48% last week. In 14 days, the deaths were up 48%. The cases were up only 15%, but I think we're still waiting to see what happens out of Thanksgiving because there's a 14-day period from Thanksgiving. And hospitalization, I'm here in St. Louis. They're putting COVID people into our children's hospital, and I think that's pretty typical everywhere. So in California, for those in California, is completely shut down. In San Francisco and Los Angeles, everyone's to stay at home. I think things are worse than they have been since early March at this point in time. And that creates huge problems for employers.
Right. It sure does. And you think about this rate, the death rate, the daily rate is about 2,800, which is a stunning number. It means approximately every 30 seconds, we are losing an American to the COVID virus. It means that during the 60 minutes we're going to convene, on average, we can anticipate 120 deaths alone during this hour. It's sobering, and it's one that impacts all of us, personal lives, and particularly the workplace, which is going to be our focus today.
And now it's starting to affect many people. My brother and sister-in-law were just diagnosed as it creeps ever closer to all of us.
That is correct. All right. Well, let's talk a little bit about the challenges that we face.
Well, I'll be glad to start. The latest unemployment figures tell us that the economy is now stalling. You've probably seen the news reports from restaurants and the travel industries that are now constrained. In fact, many of them are being closed by these new stay-at-home or lockdown orders. Both the outcome and the reason for all of the state responses is simply that the hospitals are overwhelmed. It's a matter of not only that we don't have the beds, we don't have the staff, and the continued absence of the staff will probably be the most important of all of the issues that's facing the country at this time. We can build more beds, we can't create more nurses. The unemployment rate remains high, as you saw, and the fear and one of the pressures on Congress is that all of the special relief programs from the CARE bill, the supplemental employment, supplemental unemployment, are going to end the day after Christmas, with something like 13 million people facing the prospect of having no unemployment support and no other supplemental financial support, including tax relief. So if you could stay for just a second. We can go back, right. Let me just finish quickly that the problem for employers is multiform. Not only do they have the threat of the closures, but they're looking forward to more federal enforcement across the board. We'll talk later about what California has done, 21 pages of specific COVID regulations. State lawsuits are decreasing, but whistleblower claims are increasing, and the states are now responding rather massively on their own. They feel abandoned by the federal government, so they're going to start issuing their own regulations. There's also prompting, the only word for it is nullification. Back from the pre-Civil War days, we're getting sheriffs of counties in California saying that they will not enforce the stay-at-home laws, which certainly going to be a conflict between the state and the counties. The CDC, of course, is hard at work trying to get the vaccine approved and issued, but these are very, very strange times. The vaccine rollout itself appears to be plagued by what we've suffered from the very beginning, which is a lack of a federal plan, a lack of federal funding for the rollout. So we're just in the midst of what I think the FDA leader, Dr. Redfield, said, the bleakest times in American public health history. So we are in for a few seriously bad months, but the vaccine is coming, and we hope that that provides a light at the end of this horribly dark tunnel.
Let's talk for a moment about the vaccine, because many employers, as they anticipate what a open workplace would look like, are grappling with what does that mean. What we know so far about how the vaccine will be staged is that as it's made available, the delivery, there's been a lot of discussion about how the delivery will occur, but it actually will be the states that determine which of their citizens in the sequencing, which citizens are eligible first to get the vaccine. Generally, we anticipate that those that are in healthcare, emergency response, et cetera, will rise to the top of the line. Then there will be those that are the elderly that are in assisted living environments, and then it'll cascade down from there. But one of
but
the
each state has the authority to change what the CDC recommended. Some may move transportation workers up farther up. Some may move retail workers farther up. We simply don't know yet.
So we're anticipating a patchwork varying from state to state.
Yeah.
As employers beginning to think about that, one of the questions, particularly if you're not in one of those critical transition, are you going to require your workers to receive the vaccine? Is it going to, at some point, we are going to reopen the workplace? Will it be a condition of allowing people to return to work? There is broad authority that employers have to impose the obligation to receive a vaccine. And if you pause for a moment and think about it, most of us have received a number of vaccines through our school system. As school students, we're vaccinated on a number of serious diseases. So this issue typically doesn't come up. It came up during SARS earlier. It's come up in some cases for influenza vaccines. But the question would be, can an employer impose that obligation? The answer is generally yes. There are some exceptions. There are exceptions, and the employer's interest is greater when you're in the healthcare, the emergency responders, depending on what kind of workplace. It lessens arguably for different workplaces. So, and the EEOC is working on updating its guidance, but it has pretty detailed guidance out there regarding the two primary bases for individual objections are religious objections and ADA accommodation issues. So those issues will get vetted out eventually, but I think at this stage, this is an opportunity as employers look forward. The vaccine's coming with the workplace. I mean, it's very dark in the next 2 months or so, but this is the planning opportunity to envision as our workforces become vaccinated, are we going to require it? How do people come back? Do only those that have been vaccinated, are they allowed back? Others are not. There's a host of issues like that that are worth sorting through.
Also, we have to
and
look
David,
to
one other thing.
the conflict. Whoops, sorry, go ahead, Nita.
Go ahead, Nita.
I just wanted to mention the 2.2 million women have left the workforce since March. This has been, they're calling it a she session. This has been just traumatic on women. And I just saw, in addition to all the things you were just talking about, David, pregnant women being required to come back to work, or perhaps being required to take a vaccine. Here's a whole nother set of challenges for women as well.
Agreed.
And overlaid on top of all of this is, of course, the conflict between the states and the federal government as to which, some states may pass mandatory vaccination rules that conflict with what the EEOC may be saying. The whole religious objection, the anti-vax movement. These are going to be very complicated times. It's not going to end simply because there's a vaccine present.
Correct.
And employers are going to be, of course, at the front of the battle.
That's right. So employers, though, at this point can begin to at least sort out in their own minds what their preferences will be. Are we going to mandate a vaccine? What that would look like? Who among, if we do we have to pick and choose? Is all of our workforce going to be vaccinated? What would be our priorities? I mean, these are questions that will vary, and there's not one single right or wrong answer. But the planning, this is a planning opportunity, and employers, well counseled, careful employers should be taking advantage of this time to think through, so that when all these uncertainties get figured out, the states you're in announce, we have the vaccine available, you're poised to move. All right. Anything else on COVID, which is probably the greatest challenge, but the one
I was about to say, everybody is now focused on the election and this crazy transition and the challenge to democratic principles. This is the year of COVID. And the fact that we've lost 250,000 people already, and the fear is doubling that number by March, everything else seems to pale in comparison to this tragedy.
Okay. Well, let's talk, let's switch gears a little bit and talk about the lame duck and transition. And I can lead this off. There is a lot going on, and a lot of it directly impacts employers in the workplace. So what we want to do is see if we can filter all of these broader events and get them honed into with respect to what we as advisors to employers need to focus on. First, the COVID relief negotiations continue. And Bert, I know you were just updating me a moment ago. Why don't you share that update on where we are?
Yeah.
This is as of within the last hour.
There have been
pretty dynamic.
Virtually within the last hour. There has been an effort, as you understand, both parties are under enormous pressure to try to get something done. There's been an effort recently to see if they can combine a COVID relief bill of unstated nature. We'll talk about what's in it. With the budget bill, which must be passed by December 11th, because that's when government runs out of money and there's a shutdown. The difficulty is combining two gigantic bills of that kind, both of which are still not fixed in terms of what their constituent elements are, by the 11th is probably impossible. So the last thing we heard last night and this morning is that Congress is thinking of passing what they call a continuing resolution for the budget bill, which means that will give themselves another week or 10 days. Funding will stay in place for another week or 10 days so they can try to hash out the various constituent elements of both the budget and the COVID relief bill. I'll go back to David and let him tell you what they're thinking of putting in these bills, but that seems to be the general status of where the action on the bills is.
So in terms of COVID relief, recall that months before the election, the House, the Democratic-led House, passed a very robust COVID relief bill. And it included individual funding, it included supplemental unemployment, it included relief to states, it included many things. And the price tag was around $3 trillion with a T, $3 trillion. As the election got closer, Speaker Pelosi had dropped down to about 2.1, 2.2 trillion. Steve Mnuchin, who was supposed to be the chief White House negotiator, was at 1.8. President Trump announced that he wanted to exceed what Speaker Pelosi was offering, so he was off there. But most importantly, candidly, was Senate Majority Leader McConnell remained at $500 billion. We all know there was no relief bill passed. Now we have the election. The upshot of the election, one of the takeaways is that the Democrats down ticket lost ground. And one person who's a good student of how to count votes is Senate Majority Leader McConnell. McConnell has largely held pretty firm. One of the components that he wanted was some form of relief, liability safe harbor for businesses. Not a pure pass, but if the businesses in good faith complied with what the regulations or the CDC guidelines were at the time, they should not face liability. It's kind of a common sense approach. That was very controversial, as was funding of some of the states. Ultimately, there's Nita Beecher joining us. Hi, Nita, welcome.
Nita,
hi.
So one of the components of the evolving, as Bert's described the framework, is it looks like there's going to be some element, it's going to be the half a loaf. And I might point out, in anticipating President-elect Biden, and yes, we do refer to him as President-elect Biden among us because we think that is the truth. The half a loaf approach is what is going to be valued. And so it will be a compromise. There will be some form of relief for employers, some maybe not as deep a safe harbor as someone like, but there's going to be one. There's going to be some unemployment insurance supplement because the UI runs out. $600 was viewed as being a little rich because it resulted in a lot of workers making more money on unemployment than they did when they were working, where everyone agreed that wasn't what was intended. Supplemental monies to the state, some, not as much. I mean, the whole point is many of the buckets are going to be represented, but on a smaller scale. All indications are that President-elect Biden has quietly been behind the scenes encouraging that this resolution be put in place. He recognizes both the importance, and I don't think at this point he's terribly concerned about who gets credit or not. He wants the economy propped up so we don't fall off the edge the end of December. The final thing, and so that looks, and Bert's made the point on timing. Yes, Bert, then I want to go to the Defense Appropriation Act.
There are a couple things that are still up in the air. The CDC had earlier announced a moratorium on evictions as part of a health proposition. That will expire at the end of the year, and we don't know whether they will renew it or whether Congress will add that to the COVID relief bill, but it is critically important for millions of people. I think they're like 30.4 million people are either renters or facing foreclosures. So it's a very important bill. The other issue that's up in the air is whether people will get a $1,200 or $1,000 check like they did back in March, which would pump a lot of money to a lot of people very quickly. And that is also up for discussion, still not resolved. I think one of the, David, you started with, I think this shows the diminished power of Speaker Pelosi and the Democratic bare majority in the House. And this may be a harbinger for what legislation looks like in the Biden administration.
However, there does appear to be some consensus. For example, the defense appropriation. Of all the appropriation bills, the Defense Act is viewed as the must-have. The most of the agencies could run on a rollover of last year's budget if they had to. Defense doesn't work like that. So the president has indicated that he would leverage that opportunity. One of the provisions in the defense bill is that it will have the renaming of the bases from those that bear Confederate general and other military Confederate leader names. President Trump early on, as part of his campaign, said that that's a non-starter and he would veto the bill. Since then, he has expanded the veto threat and to more of a non-defense issue, dealing with the exemption that the technology sector companies have for liability for what gets published on the in the social media context, and whether there should or should not be liability for those. The response, I mean, the president said, now, therefore, if you don't impose an end to that exemption, I'm going to now veto the defense bill on that basis. Interestingly, the congressional response, bilateral, both houses and both parties, has been a bit of a shrug of the shoulder, which is that's not germane to the defense bill. We're not going to go with that. And if you veto on that basis, we will override your veto. It's very interesting because the president's threat begins to recede a little bit. It would be the first time that one of a major veto would have been overridden of this president, interestingly, in the final week or two of his presidency, and represents, and he appears to have receded. Maybe, I'm not going to predict that. All it means is the budget, the COVID relief, the lame duck period of Congress moving forward is extremely confusing and very, very active at this point. Finally, Senator McConnell, who has limited bandwidth on convening and how he uses official Senate time for voting, continues to prioritize judges. And there are a handful of judges who've been cleared out of committee, and those will, I mean, a not very bold prediction, those are all going to be confirmed before this Congress is done, and McConnell will see that that occurs. All right.
And David, that's more than 40. That's more than 40 judges are currently sitting up there.
Right. So we could have a big uptick.
Nominees.
Yeah.
Yeah.
All right. Well, let's keep moving here and talk a little bit about what we can expect.
Well, I'll be
more specifically.
Yeah. Well,
go ahead.
Crystal ball gazing is not anybody's specialty, but we'll do our best here. We try not to be too political and try to stick to the facts. So we go to the next slide. These are pretty much what has been announced by the Biden-Harris transition team. You know, control of the Senate is hugely important for confirmations, for controlling the agenda, for controlling committees, but it is not definitive with respect to legislation, because even if, for example, the Democrats succeed in both of these by-elections or these runoff elections in Georgia on the 5th of January, the filibuster is going to remain in place, which means 60 votes are needed for most major legislation. And as we're seeing now with the COVID bill, that means that there has to be either some bipartisan agreement or there will be no legislation of the kind that is in the Build America Back Better platform of the Democratic agenda, which means that, like President Obama and like President Trump, the Biden administration will likely pursue its agenda through executive orders. On the other hand, what the president can do and will do quickly is rescind a number of the Trump executive orders, particularly with respect to DACA, with respect to diversity training, with respect to logging, drilling, WHO, things of that kind, all of which have enormous rollovers of importance to the employment sphere. Obviously, agencies can change their memoranda, can change their opinion letters, but those take time. You have to think about what you can write, what you can't succeed in producing, what will pass judicial muster. The one thing that you should remember is the Democrats are good at this. I mean, Trump administration lost dozens and dozens of cases based on the fact that they were hasty, arbitrary, and capricious, didn't follow the rules. The Democrats are kind of good at this. They, believe in government and do this. And although there is a lot of criticism that we're seeing the Obama administration point to, the flip side of that is there is no on-the-job training for this crowd. They know how to do this sort of administrative work, and they will get to it very, very quickly. Regulations, on the other hand, once they're installed, take a great deal of time to counteract, but if they can be halted, they will. For example, the joint employer regulation has been stalled in court and has been appealed, and that takes some time, but we may have a new position from the new Justice Department under a Biden administration with respect to whether they want to pursue that appeal or have an opportunity to rewrite the joint employer regulation. So those are the top elements that we can expect from the Biden administration. David, please.
Yeah, just a couple of points to build on that. With respect to hitting the ground and executing more quickly, if you look at the people that are on the agency review teams, as they're now called, they are all former Obama second-term administration leadership. Leading the review team for the Labor Department is Seth Harris and Patricia Smith, the former Deputy Secretary and Solicitor of Labor. Leading the review team for the EEOC, former Chair Jenny Yang. Deeply involved in the review team involving the Department of Justice, Hy Feldblum. These are all people who've been in these agencies whose current practice and efforts involve keeping abreast of the policies, the regulations. They have been rewriting and preparing for this for years. So they are really, really ready. Second, with respect to the halting the regulations, there will be a memo that goes out on 12:01 in the afternoon on January 20th from the acting head of Office of Management and Budget, directing on behalf of President, then just sworn in President Biden, that all regulations that are being worked on, that all work shall cease. Nothing more is to be sent to the Federal Register. Nothing further goes out until it's finally reviewed and approved by the new administration. So that's why there's this 11th hour rush, and that's what happens literally right at that moment. Nita.
David, one thing that happened in the Trump administration was a number of regulations, like what we've called blacklisting, for example, were subject to the Congressional Review Act. Is that likely something that we'll see moving forward as to some of these Trump executive orders? Although, as Bert pointed out, we have a very divided Congress, so they may not be able to push them through, even if they get the Senate.
I think the division of the legislature is the answer. It's not going to happen.
Right. Let's talk about the next slide.
We can go to the next slide. We can. Yeah, those are the hopes of the Biden-Harris administration. These are some of the challenges. The continuing defiance of the election by President Trump is really having a deleterious effect on people's confidence in government. There was a recent survey over the weekend where all 270 Republican office holders were polled as to whether they would acknowledge that Biden had won the election, and 249 of the Republican representatives refused to do so.
Said
That
no.
tells you the kind of divided government we have, and perhaps the kind of obstructive Congress we will have. So the slim majority in the House and hostile Republicans in the Senate are going to have the effect of limiting the success of the Biden-Harris legislative agenda. We just talked about that's why they're going to go the executive order route. Check back in after January 5th. Who controls the Senate, as I said, is enormously important for confirmations, for committee chairmanships, and for establishing a legislative agenda. Because of the nature of term appointments at the major enforcement agencies, such as the NLRB and the EEOC, the majorities on both of those agencies is going to be controlled by Republicans well into the first and maybe even the second year of the Biden administration. One of the issues now is whether the general counsel of the NLRB can be fired. Apparently, as a matter of law, it might be possible. It's never been done. But the general counsel, of course, controls the kinds of cases that the board gets to hear, kind of like the Supreme Court taking certiorari of cases it will hear. So that is one of the things to think about looking forward about the aggressiveness that the Biden-Harris administration will take on this front. And behind everything, not only COVID, of course, but that we are inheriting a multi-trillion-dollar deficit. We are already hearing from the Republicans who created this deficit that they are now returning to being deficit hawks. Those of you who have a long memory you have heard this song back in 2008 after the financial crisis, that we can't really do much because of all the deficits. You're going to be hearing that again. And it will be a significant barrier that the Biden administration will have to face going forward. These are interesting times. Maybe we can move on to what the hopes are, or what the possibilities are, David.
Priorities. Nita, do you want to cover those?
Yes, absolutely. So if we can go to the next slide. So what are we talking about that we know that are top on the list? OSHA. Absolutely. We expect an OSHA emergency rule, probably, I suspect, maybe the day of the inauguration or the day after, on his COVID team. President-elect has David Michaels, who was former head of OSHA. He's on the task force, so you know they're working that. And California has a very detailed, as Bert mentioned, plan already in place. I think the next thing will be the PRO Act. PRO stands for Protecting Right to Organize Act. It was passed by the House after the 2018 election. It would substantially expand union rights. Interestingly, it would allow people currently classified as independent contractors to be given the status of employees for purposes of the union organizing. So we go back to the next thing is, who's an employee is everything in the world that we live in as far as employment and labor law, because people who are employees are protected and they can organize and they are covered by Title VII. People that aren't employees are not protected and not covered. And so the next slide, the next bullet really talks about that. Independent contractor will be back, joint employer. I think if you pull up the list of executive orders that and other guidance from the Obama administration, we'll see a redo on all of those. I expect we're going to see an expansion of paid leave, for example. And David, I think the most important thing for people on this call to recognize is, as federal contractors, you guys are going to carry the burden. You're going to carry the burden of anything in the Biden agenda that can't be passed through Congress, which is a lot. And I think it won't just be, 11246 and some of these things. It's going to be a much more expansive group of regulations, perhaps something around the PRO Act, something around OSHA obligations and so forth. And I think increased access to health care, we may have, instead of Obamacare, we may have Biden care. Anything else, David, before we go on to the next slide?
No, I think that's it. I think those of you that have federal contractor and obligation compliance, your portfolio is going to grow in the next first 6 months of the next year. All right, well, let's talk a little bit about what else may be possible with the administration. Nita touched on paid leave, and one of the interesting outtakes of the COVID pandemic is that we did actually on a federal level provide expanded paid leave. Federal contractors know that you're under an obligation for those workers that provide work related to the performance of the federal contract to provide sick leave. But for the first time, we actually had Congress, albeit as an emergency basis, part of the COVID relief bill, but provide for paid leave. And to Nita's point earlier, the paid leave provision included in COVID also extended to independent contractors, so those that did not have a traditional employer-employee relationship. There's I think a major lesson learned, and both employers as well as employee representatives recognize the value and importance of that. And when you talk to very diverse groups, from the AFL-CIO on one end of the spectrum to the U.S. Chamber of Commerce on the other, there is a growing consensus of, yeah, we should probably have some sort of national paid leave program. Now, how to get there, the details matter, the interplay with various state laws, obviously there's a zillion details to work out. The difference is there's no longer how do we avoid this, it's how do we accomplish this, and that seems to be the growing sense we're hearing from the employer community. I think that's good. And that also would implicate, what do you do with this patchwork of state and in many cases local requirements? Do we use the P word, preempt? Are they set aside? Is it optional on whether you come into the federal program or not? Would it set aside state or local requirements? All to be worked out, all under active discussion. But this also goes to the concept of actually trying to reimagine workplace law in the 21st century. Think about it. We still are arguing about how laws that were enacted at World War II or before, so 50, 70, 80, 90 years ago, are going to work in today's economy, where everyone's working, many are working virtually, many are working in ways that were never imagined, and many are working in multiple settings during the course of a day, e.g. contractors, the so-called gig worker. And it's not just those that are driving delivery services or ride services. So reimagining that and how we use artificial intelligence and what role that plays. I mean, Illinois has taken a lead. Again, it's if you collect certain data, personal data using AI, you have to inform consent. Well, is that the model? Are there other ways of harnessing that? Those discussions are occurring. The re-expansion of the ESG CSR concepts are part of this. That is a natural outgrowth of the Black Lives Matter discussion, I think, and greater willingness, accountability, and interest in addressing these issues. And also the growing trend that we're seeing to use the SEC, and this was something that was looked at before for governance to impose obligations. California has created effectively set-asides for certain employees, certain seats rather on boards, to be filled by whether they be women, persons of color, what have you. Is that the right approach? Is that the way to go? How are we going to do this? There's recognition that more efforts need to be made and a willingness to begin to explore those policies. So I think all those in the next 12 to 24 months, these buckets, if you will, represent the areas where there's likely to be some consensus because both sides want these changes. The how you do it is still in dispute, but the objectives are becoming much more closely aligned than we've seen in a long time, which I think creates some reason for hope that there will be those changes. All right, let me pause there. Questions, comments, Nita, and then Bert on that. Anything?
All I was going to say is I think if you see the way this proposal is rolling out right now to get the budget done, to get the COVID relief moving forward, you're going to see that from a President Biden because he knows the Senate, he knows these people, And I think there's a real possibility that if people are willing to compromise, we can get some of these accomplished.
Yeah. Bert?
I'm a little less optimistic because I've seen the McConnell Senate work the last 10 years, and I see no basis to believe that they're going to change. The other thing that I think is really kind of important for us to focus on is to remember Proposition 22 in California, which was the proposition that the people overwhelmingly voted to create a third way for gig workers. Whether it's a good bill or a bad one or a good proposition is for others to decide. It does indicate to us that there is a feeling that we have to find some way to
Correct.
bring more workers under legal protections and to find some way of bringing our labor and employment laws to meet the conditions of the 21st century.
Super.
I think that's right.
All right. Well, let's pivot from those sort of general objectives at the federal level and talk a little bit about the agencies themselves. And Nita, why don't you start that discussion for us?
Sure.
Thank you.
Well, let's start with OFCCP, our favorite agency. And of course, as we're getting ready to prepare, first thing this morning, out pops the OFCC's final religious exemption regulations, which we've been waiting for since September of last year, because we submitted our proposal. I think the most important thing that I was able to read, obviously they're very long and detailed, is this comment by OFCCP this morning that's in their final rule in the preamble. OFCCP anticipates this rule will have no effect on the vast majority of contractors or the agency's regulation of them, since they do not and would not claim the religious exemption. It really applies to religious organizations and to closely held companies, read Hobby Lobby. So we'll know more as we get a chance to read through that. I think another important thing, though, to point out is, I think the point is that for most of you, it's not going to have an effect. Whether it's going to have an effect down the road on how you accommodate employees who claim religious objections, especially to working with LGBT or attending meetings, diversity and inclusion meetings and so forth, that's a different question to which we don't yet have an answer. It's very important for you all to know, at least for the next, until the 20th of January, that as of November 20th, your contracts will include 13.950, prohibiting diversity and inclusion training of certain kinds. That has been issued in the DFAR, so you all should keep an eye out for that and continue to look at your training. Director Lean is pushing very hard. Yes, David, go ahead.
Sure. That point? I want to make sure that people understand an action item on that is you should consult with and alert your contracting officials, those who might be securing amendments, updates, work orders, purchase orders. It's not necessarily, a lot of people think, well, I'm not getting a new contract in the next 4 or 5 weeks. It can be a whole variety of mechanisms that impose this new obligation. Now, you may not be able to avoid it because the agencies are supposed to put it in during this time, but you at least need to be aware of it because you're in a materially different position if you're under contractual obligation because it's been incorporated in your contract. So this is a really important takeaway point, and most of you on this call are not the people that actually are on the contracting end of your organizations, the procurement officials and others. You need to alert them and make sure they understand to be on the lookout for any provision, the DFAR provision that references 13950. Thank you, Nita.
Correct. Yes. And absolutely. And also just keep an eye on your DE&I training and any complaints you might get internally. David, I wanted to talk a little bit, if you don't mind. Oracle and OFCCP just completed what has been very long-standing litigation. I'm just going to read to you, David, and then you can comment. As part of that, Director Lean said the following: after nearly 4 years of litigation and investing intensive resources, the Department of Labor has determined not to appeal the 278-page recommended decision and order of the ALJ in OFCCP versus Oracle. The ALJ held a 9-day trial and based most of his opinion on credibility findings and lack of supporting qualitative evidence. The Solicitor of Labor and I have decided not to pursue the case further because we believe the likelihood of prevailing on appeal is low, and because, and this is the most important part, I think, David, because OFCCP no longer evaluates compensation in the manner rejected by the ALJ in this case. Instead, OFCCP will learn from the decision in an effort to improve the efficacy of its critically important compensation program. So, David, what are your takeaways from all that?
Let's pull back. And I had the privilege of being co-counsel for Oracle so that people know whatever biases. So one is I've enjoyed catching up on my sleep because last week was very intense leading up to that result. But I will say, first of all, it is recognition by the agency of the results that were in hand. And to give the agency credit, even before the ALJ's ruling, the agency had said it was no longer going to evaluate compensation in the manner it litigated, taking the types of very broad groupings, not accurately modeling how the employer made compensation decisions. In fact, putting an expert on that said that she didn't care how the employer made compensation decisions, and using a very detached and ultimately, as the judge found, to be legally unsound and unpersuasive method. So it is a huge relief to the contractor community that with this kind of Alice in Wonderland experience of having the federal agency come in years after compensation decisions are made and deploy a standard that no one had ever heard of or the courts had never recognized and say, here, we think that you're lacking. And indeed, when traditional, and so the agency has announced a return to Title VII principles as recognized by the Supreme Court on down. This is not some radical right-wing, it's mainstream body of law. The judge's 278-page decision on Oracle followed mainstream body of law. And the difference now is that we actually have the Labor Department recognizing, saying, yes, we will follow the mainstream body of law. That is good for everyone, all the regulated community, for certainty, for designing compensation programs, and being able to assess whether you do or don't comply, and whether remedial actions are appropriate. So I think in the long run, I have a lot of respect for Director Lean and Solicitor O'Scanlan for stepping up and owning this. I will say I'm sure it was not a totally popular decision within the building. The career people who had spent 8 years and plus trying to derail this one federal contractor, causing the federal contractor to spend tens of millions of dollars in defending itself and subjecting it to one of the biggest hearing in the history of the Labor Department. You know, they don't feel that they were particularly fully treated well by the Labor Department. But on the broader picture, I hope the new administration will follow Director Lean's lead on this. We've learned our lesson. We're going to follow the law and we're going to stick with it. So, you know, we're going to be optimistic and we will see. It is important because the new administration we know is going to focus on compensation issues. So I'm hoping between the Oracle decision and the Analogic decision earlier in the Trump administration, which also rejected the same type of similar methodology, that we now can with confidence look to OFCCP to follow the rule of law.
And David, we're getting close on time, so I think I'm going to let it go from there. But I wanted, as we go to the next slide, we did have a question about whether we believe that OFCCP will continue to have focused reviews in the new administration or will go back to just traditional audits. And I think, David, your thought was what? That they are going to maybe do somewhat?
Look, I think they're going to focus more, they're going to go back to focusing on broad-based audits. They're going to focus primarily on compensation. And to the extent that these focused reviews were diverting and not allowing the agency to successfully, more aggressively pursue this, I think they'll back off of them a little bit. They'll pick up 503 and vets in, you know, regular audits. Let's talk about EEOC.
Well, I'll be glad to do briefly. Not a lot of action, but there is action on the religious freedom front, if the OFCCP talked about, what an employer activity can be, that is to say, who they would hire, who they would not hire, the EEO looks on the employer response, which is to say how an employer would respond to a request for an accommodation. And it has broadened the base to such a degree that there's an implicit overturning of the Supreme Court decision in TWA versus Hardison, which said that an employer only had to do a de minimis to accommodate. That's been completely flipped in my view. Any de minimis request is going to have to be honored. And that's pretty much what the EEOC guidance indicates to us. They've taken action in Walmart and Kroger in support of an employee request for an accommodation from wearing the marketing costume, the marketing logos of these companies on the grounds that they implicitly supported the LGBT flag and therefore the LGBT agenda. And the EEOC, quite surprisingly, is supporting the employees. Just very briefly, they recovered a great deal of dough, more than ever before. And on a more positive note, their website has acted on their hope for transparency by expanding and making access to EEO1 data more accessible. Whether employers like that or not is another matter, but the EEOC claimed that they would become more transparent, and this is one of their efforts to do so. And I think the big issue for the EEOC is who's going to stick around for how long, and who will be able to replace them in light of Senate confirmation. And we'll stop here in light of the time.
Okay. Well, I'll move into DOL, and while we're getting there, I'll just say that Chair Dillon, she is likely to remain the chair until the expiration of her term, which would be for another year plus. Over the first year of the Biden administration, the EEOC will continue to have a Republican majority with the new members there. All right. With respect to wage and hour, 2 new opinion letters. Again, these can be rescinded with a pen stroke by the incoming administration if they opt to do so. The Trump administration rescinded, the Obama administration rescinded Bush opinion letters, so the same may occur to the Trump opinion letters. The first involves those of you that have piece rate workers, an important issue in how you calculate the regular rate. And it allows you to take into account non-productive waiting time in between the piecework. So it's that's a very helpful letter. The other is a much more nuanced letter involving agricultural workers, probably not broadly applicable. More importantly, on the big sphere is there are new regulations still coming in the final 30 days, and those are going to involve the independent contractor / gig worker and tip pooling. So anyone that has workers in that sphere, look at those, because as Bert has explained earlier, those regulations will be on the books. They will be final regulations, and the incoming administration will have to go through notice and comment in order to lift or eliminate them. All right, let's talk briefly, Bert, about the NLRB. I'm sorry, I missed.
Be happy to.
Well, I'm sorry,
I missed OSHA. Let me just, the most important.
Let me check on OSHA quickly. We don't expect anything materially different between now and the end of the Trump administration, which means no new standard. However, as Nita mentioned earlier, we do expect the new administration to impose an emergency temporary standard, ETS, very promptly. We have every reason to believe it's fully written. It can go in without notice and comment. It can be implemented immediately. And I think you can look at California or Michigan as the 2 likely models, and that will immediately expand and extend to all federal workplaces subject to OSHA. It will put specific requirements in place that all employers, practically all employers certainly that are joining today's call, will need to meet. There was an inspector general investigation of whether OSHA was giving short shrift to whistleblower complaints. It found that was not the case, had some deficiencies with respect to procedural issues, nothing material. And there were efforts made, there continues to be efforts to micromanage OSHA through litigation, primarily through the AFL-CIO, and every one of those cases has been rejected. Not quite as bad as the Trump challenge to the vote count, but all the AFL-CIO challenges to OSHA have been unsuccessful. This is the most recent one. All right, Bert, to the Labor Board.
Absolutely. NLRB. I guess the most important thing to remember, it is and will remain in Republican hands. We talked about whether the general counsel will remain. He is bitterly opposed by the labor movement, and it is unprecedented. But we think there's a legal basis for making that move if the Biden administration seeks to do so. In the meantime, the board is still at work. They rescinded the contract bar doctrine, which means that a workforce can vote to get rid of a union more quickly than it could in the past. The board is trying to move forward on keeping email contact information from the unions. It's, for those of you who know the Excelsior list, we'll be back to paper under this rule. Here's where the general counsel comes in. The general counsel decides what cases get heard by the board. General counsel has dismissed unfair labor practice charges on failure to bargain over sick pay, on PPEs, a number of COVID-related issues. A different general counsel would certainly bring them to the board. Whether this Republican board would exceed remains to be seen. The Scabby the Rat has gotten a lot of press recently as to whether you can bring the Scabby the Rat to accuse not your employer, but third-party employers. In union contracts, there's a question whether that's a secondary boycott. There's a question whether it's a limit on First Amendment rights, freedom of speech. Scabby is, 10, 12 feet tall. It makes quite an impression.
He's
but
huge.
It's gotten, oddly enough, it's gotten more play than all the other issues above, which are somewhat more important. But in light of the time, I'll leave Scabby to others.
Good.
Nita?
I was just going to mention, the board has not yet rescinded the contract bar doctrine, but they could. They have it on their plate as something they could do. All right.
Yeah, it is a pending case. Sorry.
Updated on some diversity and inclusion developments in the last few minutes here.
Sure.
Can you read that, please?
Yeah, I just wanted to touch briefly as if we go to the next slide. We were talking a little bit earlier, and I think, David, when you were talking, there's still a big push to increase diversity. And I think, with the Biden administration coming in and Black Lives Matter, you're seeing a lot of this. There's a corporations stepping up and saying, we value this. Most recently, NASDAQ is proposing to the SEC that listed companies must have one woman and one person either of color or of sexual orientation on their board. You need to have one of each, and we'll see how that goes. So far, while 80 to 90% of companies have a women director, only on the NASDAQ, only 25% have minority directors. So interesting.
Just one comment, because this needs SEC
Bert,
approval that constitutes state action, and that means these quotas will probably not pass constitutional muster.
Well, we'll see. It's a good point. And so, David, I think that takes us to the takeaways, and I think you are up first, which is the next slide.
Well, Bert, do you want to talk?
No, I think I am. As I said before, this is the year of COVID.
Sorry.
The COVID resurgence is just the issue that is overwhelming everything, and it is the basis for most of the conduct you're going to have from the Congress and from the new administration. We are praying that our healthcare system survives intact with the surge of cases that is now coming to the doors of these hospitals.
Right. So the lame duck Congress, we're going to see both the COVID relief. There will be COVID relief. We're going to see a new budget. There will be, in some fashion, whether it's just a continuing resolution or actual budget appropriation bills that get passed. And the lame duck Congress actually spans, we have the current 116th Congress that runs until January 3rd. Then on January 3rd, the 117th Congress convenes. On January 5th, we have an election in Georgia. I don't know how long it will take to sort out who wins that election. It seems to take longer than it used to, but we will have that sorted out, and that will determine whether we do or do not have a Republican majority in the 117th Congress. And I might add, we will have the college voting, electoral college voting on the presidential on December 14th. So between now and January 20th, during this lame duck period, we have all of those activities occurring. And these are going to have real consequences for employers throughout those. Nita.
And again, the Biden presidency will reverse many of the Trump priorities and policies, as we've talked about, and as we'll probably have a chart that'll make it look like a flip-flop: Obama, Trump, Biden. And Bert?
As we said earlier, the control of the Senate will be decided on January 5th. There are 1 million absentee ballot requests, so January 20th may be a date when we find out a whole lot of stuff, including who controls the Senate. Control of the Senate is critical for determining the legislative agenda, confirmations, who heads the committees, who conducts investigations. But because of the filibuster rule, it will not control passage of legislation. But keep your eyes peeled on January 5th.
Perfect. All right. And finally, we've noted that the executive agencies in the final weeks and hours of the Trump administration are continuing to be aggressive and active. There will be new regulations. There likely will be more sub-regulatory guidance. Also, the regulations are important. They cannot be simply erased. The other things can be pretty quickly. So the next 60 days, very, very active period. And of course, we have the holidays in between. So that's what we see coming up in our crystal ball. Thank you for joining us today. Next slide, please. We are going to reconvene on January 11th. So hopefully then we will know who has prevailed in Georgia. We'll have a much better informed view on the incoming Biden administration, what to expect. And we will be focusing on the first 100 days of the Biden-Harris administration and all the last-minute changes that have occurred during the Trump administration. So I want to thank both Bert and Nita for today. Wish all of you a really joyous and safe holiday season. Please rejoin us next year on January 11.
Thank you, folks. Stay safe.
Thanks.
We would like to thank you for joining us. As a reminder, all registrants from today have been registered for future briefings, and you may view this briefing as well as our previous COVID-19 weekly briefings on our website at www.FortneyScott.com. The next monthly briefing will be January 11th, 2021. Please be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing this survey, and of course, if you have any questions, you may submit them via email to info@FortneyScott.com.